Baker Botts, LLP provides podcasts for educational purposes only. They are not legal advice and are not intended to establish an attorney-client relationship. This communication may constitute attorney advertising.
Welcome back to the Lawful Influence podcast, where we pull back the curtain on legal issues in the world of campaign finance and lobbying. I'm your host, Sterling Marchand, coming to you from Washington, D.C. In today's episode, we're going to cover some breaking news out of the state of Minnesota, where the governor recently signed the Democracy for the People Act. This new law included comprehensive revisions to the state's campaign finance, voting, and election laws. With the passage of this act, Minnesota became the latest state in the country to prohibit so-called foreign-influenced corporations from making certain political expenditures in the state in connection with elections. But the reason we're going to be discussing this today is that the Minnesota Foreign Influence Law is the first in the country in two critical ways. First, it applies to any political expenditures in the state, whether for federal or non-federal elections. Other states that have targeted foreign influence in campaign finance have limited their laws to only non-federal elections. The second reason Minnesota stands out is that they use a very low threshold for their definition of foreign influenced corporation. They defined it as any for-profit company where a single foreign investor owns 1% or more of the company. So that's why we've entitled today's episode The Mighty Bucks, which, by the way, if you've made it this far in the podcast, maybe you've noticed that each episode title is a reference to what I consider to be a classic movie. Keep tuning in to see how long I can keep this going. Today's reference, of course, is to the 1992 hockey comedy set in the great state of Minnesota, not Anaheim, of course, and stars Emilio Estevez as a defense attorney turned hockey coach. Now, Minnesota's law is a somewhat belated response to the Supreme Court's decision in 2010 in Citizens United, which paved the way for corporations spending unlimited amounts of corporate dollars in support of what are known as independent expenditures. And so in this law, we're going to spend a little bit of time discussing what the law has been under Citizens United up to this point, how the new Minnesota law changes that status quo, and what this may hold for the future of campaign finance nationwide. So starting with Citizens United, in 2010, a 5-4 majority of the Supreme Court sided with a nonprofit group known as Citizens United to find that corporations and other groups can spend unlimited amounts of money in elections regardless of the proximity to an election. In that case, essentially what was at issue was that Citizens United wanted to air a movie that was critical of then-candidate Hillary Clinton. And they wanted to air that movie within a 30-day window right before a primary election. And at that time, the FEC had rules in place that prohibited that type of expenditures to influence an election. And the reason the FEC gave for having those restrictions in place was they argued that there was a legitimate governmental interest in preventing corruption. But Justice Anthony Kennedy in the Citizens United case found that limiting independent political spending from corporations violates those companies' First Amendment right to freedom of speech, and that spending money is an essential aspect of speech. Part of the majority's reasoning was that if the corporate spending was independent or not coordinated with a campaign, and it was subject to transparency through reporting requirements, then the risk for corruption would be low. So as a result of the decision in Citizens United and some cases that followed on immediately afterwards, corporations can now spend virtually unlimited funds on campaign advertising as long as they are not formally coordinating those expenditures with a candidate or a political party. So that's what we refer to as independent expenditure committees. They are independently spending money. They're also more commonly known as super PACs. And while they can raise and spend unlimited amounts of money from donors, they are subject to reporting requirements and must disclose their donors' identities. Independent expenditures by super PACs take a lot of forms, but most commonly it's going to be advertisements that explicitly support or oppose candidates. But they may also endorse candidates, hold rallies to support candidates, or make contributions to other super PACs. Now, in the 12 years since Citizens United was decided, we've seen massive amounts of spending from outside groups under the banner of super PACs. And that has accelerated in the past two elections. So in the first 8 years, from 2010 until 2018, super PACs spent nearly $2.8 billion on U.S. elections. But then in the last two election cycles, just covering 2020 and 2022, super PACs spent over $3.4 billion, more than all of the 8 years preceding. Since Citizens United, election spending through super PACs, including by corporations, has skyrocketed. And although super PAC spending supports both sides of the aisle, many believe that the decision has allowed too much money to be spent in U.S. elections by a small number of donors. In other words, some argue that a handful of organizations and wealthy individual donors have an oversized influence on U.S. elections. And there's been a lot of calls over the years for the Supreme Court to walk back Citizens United, for Congress to enact legislation that would put limits on Citizens United, or for some other means to curb the corporate spending. But so far, none of that has gained traction at the federal level, and it's been left up to state legislatures to try and control corporate spending within their state. Another concern that's been raised by Citizens United is some argue that it opened a loophole that allows foreign nationals to inject money into U.S. politics in a way that was previously illegal. Now, federal law has prohibited foreign individuals from making or participating in political contributions and expenditures. That has been true for nearly 50 years, and it is still true today. So while I can donate to a political candidate's campaign up to the yearly limit, foreign nationals, individuals who are not citizens of the United States, don't hold a green card here, they cannot. And they can't do it through a U.S. citizen. So a foreign national can't give me money to then contribute to a candidate. But with Citizens United, the door was open to that influence coming in through corporations. And some argue that because of the way that a U.S. corporation is defined, in other words, it focuses on where the company is incorporated, that means that a company that is a U.S. company could participate in super PACs in the United States, even if that company was owned by a foreign entity. And there was concern about this back when Citizens United was decided. And Justice John Paul Stevens raised this in his dissent. And he said that the majority's assumption that the identity of the speaker has no relevance to the government's ability to regulate political speech would lead to some remarkable conclusions, including that it would afford the same protection to multinational corporations controlled by foreigners as to individual Americans. In other words, what Justice Stevens was warning against was the idea that a foreign multinational corporation would have the same freedom of speech and the same ability to spend money in U.S. elections as U.S. citizens would. So ever since then, there have been calls to amend federal laws to explicitly prohibit U.S. subsidiaries with some majority foreign ownership from participating in political spending. But again, so far, there has been zero appetite to make those changes. So that brings us to Minnesota and the Democracy for the People Act. At the state level, Minnesota is not the first to prohibit or put restrictions on foreign-influenced corporations from spending money in state elections. But it is the first to do so at such a low threshold. So let's dig in a little bit to what this new Minnesota law is. First, who does it cover? Minnesota's law defines foreign-influenced corporations as a for-profit company in which a single foreign investor owns or controls at least 1% of the company, or multiple foreign investors own or control 5% or more of the company. It also includes any company where a foreign investor participates directly in the decision-making process for political activities in the United States. Notably, the definition does not include nonprofit organizations such as 501c4s or labor organizations. In effect, this means that if your company has one investor that owns more than 1% of the company, and that investor is a foreign person, you would be considered a foreign-influenced corporation under the Act. And if you're not considered a foreign-influenced corporation based on your investors today, you have to keep track of who your investors are next week as well, because as that changes, you have to continually reevaluate whether or not a foreign investor owns more than 1% of your company. What is the effect of the law? So if you are a foreign-influenced corporation under Minnesota's new law, it prohibits you from making an expenditure to promote or defeat a candidate, or making contributions or expenditures to promote or defeat a ballot question. So in essence, foreign-influenced corporations cannot make contributions to super PACs, cannot spend money as super PACs, and cannot spend money on PACs to support or defeat a ballot question, so-called ballot PACs. It also prohibits these companies from making contributions to candidates or their campaign committees. For companies that are not foreign influenced and who want to make contributions or expenditures in Minnesota, those companies will have to certify that they are in compliance with these provisions. So just because you're not foreign influence, if you want to be active in Minnesota, there are still new requirements that now apply to you. Within 7 days after a contribution or expenditure is made in the state, you must certify that you are not a foreign-influenced corporation. This is going to increase your compliance costs for doing business in Minnesota in terms of political spending. Violations of these provisions can result in corporate fines up to $40,000 or dissolution of the offending company, and individuals can also face penalties, civil and criminal. Now, this law will go into effect January 1st, 2024, and we are expecting that there will be regulations or guidance that the Minnesota Campaign Finance Board will put out ahead of time. What is the impact of the law? It obviously is going to impact foreign-influenced corporations the most. If you know that you have an investor that is a foreign national that owns more than 1% of your company, you will no longer be able to spend money in Minnesota the way that you may have been in the past when it comes to political elections. And I should note that this covers not only non-federal candidates spending money on the governor's race in Minnesota, but it covers federal elections as well. And so if you want to spend as an independent expenditure, an ad supporting the election of a senator in Minnesota, you would have to comply with this law, either by certifying that you're not a foreign-influenced corporation, or if you were a foreign-influenced corporation, you would no longer be able to do so. Again, if even one investor is foreign, this law may be triggered. Now, for privately held companies, this may be easy to determine as they typically know who owns the company. But for publicly traded companies, as I mentioned earlier, it becomes much more challenging, not just because it can change at any given moment, but also because true ownership may not be apparent. But publicly traded companies, all companies really, are going to have to go through this exercise on a regular basis. Whenever it decides to contribute or to expend money in Minnesota in connection with an election, each company is going to have to make a determination. If you can't make that determination, if you don't know definitively that you are not a foreign influenced company, your risk is going to increase because you are now required to certify that you are not a foreign influenced company each time you spend money in the state on political influence. And so by making that certification, you are opening your company and yourself to liability if it's not true. The practical effect is that only companies that definitively know they are not foreign influenced are likely going to participate in the future in Minnesota. Now, time will tell whether companies simply stop participating or whether they go through this process each time. I think the intent of the law is to drive down corporate participation. And so they expect that the effect will be much less corporate spending in the state of Minnesota. We will see. Now, unsurprisingly, this law is going to be subject to litigation. In fact, the Minnesota Chamber of Commerce has already filed a lawsuit seeking a preliminary injunction and alleging that hundreds of businesses will be harmed. And I expect that these types of challenges are going to be based on two arguments. First is going to be the First Amendment violations. As we discussed earlier, Citizens United and even earlier cases going back to 1976 in Buckley versus Vallejo have long held that restrictions on political spending are subject to heightened judicial scrutiny because spending is a form of protected political speech. So courts will need to determine whether Minnesota's foreign influence ban is sufficiently tailored to prevent foreign influence in U.S. elections or whether it is an overreach. So given that Minnesota's law prohibits a company that is 99% owned by U.S. interests, the state will have an uphill battle to show that its interests are justified and that the ban is not overly broad to accomplish its goals, even if those goals of keeping foreign influence and corruption out of U.S. elections is justified. Now, advocates analogize these bans on corporate prohibitions to the individual foreign national prohibition, which, as I mentioned at the outset, have been in place for over 50 years. But Citizens United undermines that comparison, and I think that argument is going to continue to be an uphill battle. The other argument that these challenges are going to make is federal preemption. And while federal campaign finance law does not expressly preempt state and local election law, in this case, the Minnesota law prohibiting foreign influence spending reaches federal candidates, and a court is going to have to consider whether that conflicts with the federal laws, especially given the findings in Citizens United. So that's what the Minnesota law does. That's the impact. That's its reach. Now let's discuss, what does this mean for the future? At the federal level, it's very unlikely that we will see similar legislation that prohibits foreign influenced corporations from participating in independent expenditures. Congress has introduced bills to ban foreign influence, but those have failed to gain traction. The FEC, for its part, has considered in the past whether it has the authority to ban foreign-owned U.S. subsidiaries from participating in campaign finance, but determined that its legislative authority did not extend from individuals to companies. In other words, the FEC, without additional legislation, cannot do anything to further limit the foreign-owned U.S. companies. But at the state level, as I mentioned earlier, other states are considering this. So Colorado has passed a law that applies to majority foreign-owned companies. The city of Seattle has a similar law on its books that applies to city elections. And other states, including California, Connecticut, New York, Massachusetts, are all considering similar legislation. Most recently, Maine passed a similar law, but the Democratic governor vetoed it. That will likely be a referendum in the state in November, put to the voters to decide whether or not they want to enact a ban. The Minnesota ban and other bans like it present challenging compliance issues. And Minnesota goes farther because it includes 1% ownership and extends to federal elections. So companies will need to know whether they are foreign influenced on any given day if they want to make contributions or expenditures in Minnesota. And it won't be enough to just limit your activity in Minnesota to federal elections, because the reading of the new Minnesota law is that it extends to any political spending within the state. So stay tuned. We expect to hear more out of the Minnesota Campaign Finance Board as to guidance as to how companies are going to be expected to comply with this. But companies should be aware that this change is coming, that it goes into effect on January 1st, 2024, and that if you or your company are active politically in the state of Minnesota when it comes to independent expenditures, when it comes to supporting or opposing ballot questions, that this is a new regulation, is a new requirement that you're going to have to comply with, or else you run the risk of facing some pretty harsh penalties. If you have any follow-up questions on this or want to know more, my contact information is in the episode notes. If you simply want to recommend future movie references for titles, by all means, feel free to reach out. Until next time, I'm Sterling Marchand. Thanks for listening.
Thank you for listening to this Baker Botts podcast. Baker Botts has the experience, knowledge, and people to solve our clients' most significant legal issues. For more information on Baker Botts practices, please visit us at bakerbotts.com. This presentation is provided by Baker Botts LLP for educational and informational purposes only. It is not legal advice and is not intended to establish an attorney-client relationship. Under the rules of certain jurisdictions, this communication may constitute attorney advertising.